So, so there was that decision was very clear in my head, but I didn't know how to go about it, when to start on my own, which lawyer, which office should I be joining to begin with to learn good work. And I probably, like everybody else, it just kept happening by default. But by the end of it, you do realize a few things, which I would just like to share with everyone here. So eventually, after 3 years, I mean, I had put in 1 year each in different offices. I started with somebody in Supreme Court. He was the president back then of the Advocate on Record Association. So there was a lot of filings from his office on daily basis. So I happened to join that office first, and the first day wearing those robes and going to Supreme Court in itself was a very great feeling for any lawyer. And but gradually I realized that you are just a very, very minuscule part. I mean, you are not even a part. You can't even call yourself to be a part of that whole ecosystem, because it's so huge and so wide that it can scare you away if you don't have somebody mentoring you continuously, if you don't have anybody to guide you, or if you don't have anybody answering your questions, because there are thousands of questions which actually keep troubling your mind day in, day out. So it becomes very, very difficult for a person. It is very easy to come into this profession, to start on your own, but it becomes like 100 times more difficult to keep you going, right? Because all those questions, and especially when you, like I said, you keep looking at your peers and you start comparing your paychecks with them, it becomes even, there are always question marks which are clogging your head. Whether am I doing it right? Whether am I supposed to take pro bono cases? All of those questions and several others just keep haunting you. So I think after my first stint in that office, one thing I was very sure of was that I've become a Supreme Court lawyer. I mean, I started treating myself as one. And then I realized when I joined thereafter trial court lawyer. So I realized that whatever I learned in that 1 year was not even probably, 5% helpful there. It was just the research that I may have conducted on the regular basis, or the points of law that I had seen, but I didn't know how to conduct a trial. I didn't know how to, address the trial court, because addressing the trial court is altogether a different phenomena. It's very different from addressing the Supreme Court. Although the judges in the trial court used to get impressed when I used to initially address them there, but I saw that everybody around, was talking in a local language and was addressing the judge in a very different manner. Like we could never think of addressing a Supreme Court judge as a janab, and nobody else in the trial court would. Usually 80% of the people or 80% of the lawyers appearing before a trial court judge would call him a janab. So just to the culture was very, very different, and so was the practice. So then when I spent another year in that office, I realized that the tricks of the trade, or the tricks of the profession in the trial courts. And thirdly, then I joined an office where I was lucky to work with people who were later on, went on to get designated as senior lawyers, senior advocates. So I could see good work at the Supreme Court, at the trial court level, and then I joined somebody who is now a senior designated advocate, but he was practicing mainly on the telecom side, in the tribunals, in different tribunals, High Court, and the Supreme Court. So it just kept giving me the insights about different areas of practice, different styles of practicing, different ways of arguing, different ways of articulations, and how do you maneuver your ways through the court. So, I mean, it was all very, very insightful. How is it different being a trial court lawyer, right? That the entire ecosystem seems very different when you go and visit a trial court vis-a-vis when you go and look around. I mean, you visit High Court or Supreme Court for that matter. The environment, the entire system looks very different. So the trial court is, I would say, makes you the toughest. It's like, if I now draw a parallel between a legal profession and say architecture, so a trial court lawyer is like a mason. He will lay the foundation. He will start putting the first lot of bricks together to make some sense. And if the bricks are not laid, and if the foundation is not laid or dug up in a proper manner, it may have an effect on the entire building. So what happens at the trial court stays in the matter till the Supreme Court. It's very, very different. It's a basic. And if the basics go wrong, nobody ever can correct those basics later on. So meeting the client for the first time, understanding from him the problem that he's facing, then looking in the law books or looking into the acts, different acts, to find a suitable remedy, the most efficacious remedy, then to convince them to, adopt that remedy and then to pay your fees is an art which every trial court lawyer needs to learn. And it is very different from, trust me, from being an appellate side lawyer or being a lawyer in the Supreme Court and arguing counsel. Because there are, more street smart you are, it's going to help you becoming a better lawyer, always. But at the top level, if I talk about the top-notch Supreme Court lawyers, right, they are usually arguing the points of law, which is more academic in nature. There are facts which have been established by trial court. There are facts which have been then upheld by the High Court, or done away with by the High Court in its judgment. Then the Supreme Court, in the Supreme Court, you just need to know the question of law that you are going to argue. And it's more like an academic exercise. It's like what we do more often as a student, to read the law, to understand, to decipher it, to interpret it. That is what we are doing even now. So the best of the lawyers, so I always compare it in like 3 stages. Like I said, the trial court lawyers are like masons, who put all the bricks together, who give the shape to the building, who then finally paint that building. So all of that neat work that you see at the end of a trial has been done by the trial court lawyer, and which is a lot of work to begin from a scratch, to make it happen till the end, and to give it shape like that. It's like a huge task to bring something in being, which never existed. Then a High Court lawyer or an appellate side lawyer would be more like an architecture or somebody who would tell the who can point out fingers that where all the trial court or the mason had gone wrong in building that building, in constructing that building. So that is what we do at the High Court level. We show to the court that where all the trial court has gone wrong, where all the trial court lawyers have gone wrong, in arguing the case, and this is the fault which High Court needs to correct, which is easier compared to, like I said, bringing something new into formation. And then you compare it with the third level. The Supreme Court lawyers are like the interior designers, interior decorators. They would just come visit your house and they would say, okay, hang something here in that corner. It would make the building look more beautiful. And I believe the kind of time, effort, energy has been put in by an interior designer is much lesser than what has been put by a mason. But who gets the maximum remuneration is the interior designer, for the number of hours put in, for the effort that has been put in. So for every unit of effort, if we compare, the interior designer is paid the most, whereas he has contributed the least. He has only made it shine better, you know. So that is, I mean, the difference in the practices. So you put in a lot of hard work at the trial court level, but you don't get paid as much as the high court lawyer does. You still put in more hard work than a Supreme Court lawyer, but you will get less paid for it. Supreme Court lawyer would ultimately read your file at the time of final arguments. He would draw his interpretations, he would argue it, he would probably put in 3 days into arguments at best, and he would be the one taking away the maximum money. So, but to reach at that level, you need to have such a deep insight. You need to identify the correct questions of law, because when your matter is listed before Supreme Court, you are barely given 15 seconds or 30 seconds to make it or break it. You have only initial 15 seconds to impress the judge. They've already come well read with the files. They know what you're talking about. If you try to digress from the main point, they will bring you back to that relevant page they have already identified last evening while reading that file, and they would simply dismiss the matter if you are not good enough. So to make yourself good enough, you have to start with as a mason. You have to reach up to the level of an architect, and then you have to become the interior designer, right? So all those experiences do matter, because only then you will be able to identify the real issue that needs to be highlighted at the top level. So it's a very, very important exposure to be working in a trial court, for at least for some time, if you don't want to devote much time to it.